I'm tired of playing this game, Andrea.
At least she's registered.
It's like, when this is what happens when you're too nice. I'm gonna send her for a drug test right now. I want to see if anything that she's going to test positive for. I will not do this again.
Today, she does have her ankle monitor on. She's registered with IOP. She has orientation tomorrow, and she starts Saturday.
Okay. Was there anything else that was supposed to happen?
I'm sorry?
She was supposed to be finished with SOP and now registering for IOP, right? Wasn't that
No, she had to start. It's IOP first and then SOP. So she has to do IOP.
Weeks ago.
No. We were here
It was not
too long ago. I can pull her up, Judge. Do you have Kira Ramirez? Oh, never mind.
I'll pull her up.
If you get there before me. I'm pulling her up, Judge. She's the one, Judge. I don't know if you remember that.
I remember everything. Yeah.
Okay.
So I have here on 9/13, this is when we amended the agreement to do the 3 days and then scram upon release and do IOP and SOP. That was 9/13.
Yes, and you told her by the time she comes back, she has to be registered, which she is. She has orientation on Thursday and she's starting on Saturday. That's what I have.
Shatori, we're talking about Carol Ramirez.
I just talked to her. She had a visit with her officer, and at that point, she wasn't registered. She just sent me over the company she registered with. So I'm gonna call them. And
She's still pushing it. Still pushing it. I mean,
she goes on Thursday.
same thing. It's over and over. It's come up, Miss Ramirez. I don't understand why you are still pushing your luck. You were supposed to register immediately upon doing the 3 days as a condition. When did she do the 3 days, please?
September 20th is when she went in. And that Monday, I think it reinstated her, Judge.
She did. She was released on when, the 21st.
On the 23rd. 23rd is when she was released.
Released the 23rd. She was supposed to register immediately, starting the IOP. And what day did she register?
Yesterday.
Says her probation officer told her she had a month.
I told you here what you were supposed to do. I'm tired of playing this game, Andrea.
At least she's registered.
It's like, when this is what happens when you're too nice. It's over and over. People take advantage of you like crazy. It took 1, 2, 3, 4 weeks for her to sign up for IOP, Andrea. 4 weeks.
Can you, since she's already registered?
No, I mean, I'm done with this. I'm just, what?
Let her see if she goes, if she attends. I don't have there's not much that I can say. I don't have much to stand on. But
She doesn't take us seriously.
I'm hoping that you will allow, since she's already registered, you'll allow
Let's
her.
do this. Let's do this.
Because she has an ankle monitor on. That's on. It's
I'm
on.
gonna send her for a drug test right now.
Okay.
I want to see if anything that she's going to test positive for. And then
I can send her for
right now, I want to send her for a test. And then I guess we'll talk when she comes back. Because first things first, I want to know if she's clean. If she's not clean, it's over.
Okay.
That's it. But if she's clean, then we'll talk about how we go further.
Did I
But-
send her back here? How long, so I know how to manage everything else that I
I have
have.
your cell phone, right?
Yes.
I'll text you when she comes back.
Okay.
And I don't know. Just take a seat for a minute.
Judge, if she registered for the classes, there will be completed in 6 months.
I'm not doing a 6-month reset for her to do one class a
We
week.
can bring her to court. We can bring her to court for status updates. I'm 100% on board with that. I think that that's actually a very good idea. But what I'm saying is that the probation department feels that she could be helped with the IOP and SOP. That's my understanding. Please correct me if I'm saying something wrong. My understanding is that probation department feels that they could help her with the IOP SOP. I think that to her defense, nobody told her she needs to register, at least as far as I'm aware, to the 3 times a week. So
I told her last time we were here.
now when we approached, because I was with her,
Yes,
Judge.
I told
I
her.
was with her and I don't remember you saying that.
I told her what you need to have done, and then this is what you register for. When you come back, this is what we're gonna end up doing. Regardless, look,
Since the probation department feels that they can help her, if she can register to one of the 3, and I'm gonna bring her up here with, if you decide to allow her to continue, I'm gonna bring her up here and we all talk so everybody's on the same page. If she does it within like a week, not a month like we did last time.
I'm not ever going to reset her for over 2 weeks at a time
And that's
because I
fine.
can't trust anything to happen.
And that's fine.
And Mr. Lindsay, unfortunately, the way it works is that it's unfortunately, like a little child. They push and they push and they push. And it's childish because they push and they push to see how much they can get away with. And as evidenced here, you sign up the day before court.
This is all predicated on if the court does not rescind its order for supervision.
What I'm going to do now is I'm going to reset her for 1 week. She has 1 week to sign up for the 3-time-a-week course. She needs to come back, show us that she's done that, and then after that, I'm going to set her off 2 weeks. Every single 2
Can I bring her up
weeks.
here? So
Sure.
I want her to be part of the conversation, so if she comes back and she doesn't do, so nobody can, so there's no possibility of saying,
I'm so over this, it's just ridiculous. Come up, Ms. Ramirez. So I will indefinitely set this case off 2 weeks at a time to make sure that it gets done. Because I can't do 4-week resets anymore, unfortunately. So we are now going to have to micromanage just I don't think that this is right. And I don't think that this is fair because it really spits in the face of every single person who does a good job with this program. And what you're doing now is not what this program is designed to do. And it really violates the spirit because this is a program that's supposed to teach you right and wrong, teach you how to act in the free world. And you've done everything against that. I mean, for you to sign up for the class 1 day before court, it's just, it hurts. And it's shameful. Because when I told you, last time you were here, I told you that I wanted you to sign up immediately after you were done. And you sat there and you waited. Not 1 week, not 2 weeks, not 3 weeks, 4 weeks. So now you've shown me that I can't do long resets on your case. So if you fail one more time, if you ever fail to attend a meeting, if you ever fail to whatever you need to do, you will be out of this program. I will not do this again, and I will immediately set your case for trial. You have 1 week to sign up for the class that's 3 times a week. And thereafter, you will get 2-week resets every single time to show me that you have attended this class 3 times a week. If you fail to go one of those times in a week, because it's the class is designed for you to go 3 times a week, every week. And if you fail to do that, that's it. Do you understand?
Yes, sir.
Judge, just to make sure we're all on the same page. Judge is asking you to go back to that list that you have and find a place that offers the program IOP 3 times a week what are the requirements? Is SOP once a week or,
But she
okay,
has to complete IOP first.
right. So you have to go back to the list, find a place to register for IOP that does it, that meets 3 times a week. You do IOP, and once you're done with IOP, you find SOP that meets once a week. And you have to have,
90 days. Okay.
right, and you have to be registered in the IOP that meets 3 times a week by next court setting, which will be in about a week.
Not about exactly a week.
Okay, do I have it
Next
correct?
Wednesday.
Do I have it correct, Judge? Right, okay, so do you understand that?
Yes.
There's not gonna be another chance. Okay.
Stay has nothing further, Judge, for the court.
See you in a week.
Thank you.
Mr. Estrada, you're charged with 2 cases. You're charged with driving while intoxicated. You're also charged with unlawful carrying of a weapon. On the gun case, you're facing up to a year in jail and or a $4,000 fine. On the DWI, you're facing up to 6 months in jail. Looks like you guys have worked out an agreement where they're offering you 6 days in jail with credit for 2 on both of those cases. You need to understand that both of those cases will go on a record. They're going to be there for the rest of your life. You can never take them off. Do you understand? This is important because if you ever get pulled over, officer looks you up. They're going to see all the DWI. They're going to see the gun case. If they roll up to your car and it smells like weed, it smells like alcohol, what do you think they're going to do? Right. What we're doing today, from now on, you are facing a minimum of 90 days in jail. Do you understand? They can use these to enhance your punishment. You're looking at a minimum of 90. How do you plead to the offense? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, like I said, you can never change this. I take it the case upstairs is being dismissed?
Yes, sir.
Okay, what about the weapon? Okay, so the weapon will also be forfeited, meaning that you're not going to get it back. You understand?
Yes, sir.
I am going to suspend your license for 90 days.
Would you hear,
Drive until you get a license.
would you hear evidence on the surcharge?
Yes.
Judge, he's 20 years old. He works in a warehouse. He lives with mom and dad. He takes care of mom and dad. He helps pay for rent, pay for things around the house. He's trying to get his life together. His hours fluctuate between 20 and 40 hours a week, 40 on a good week, 20 on a normal week. He's 20 years old, just turned 21 now. 22, I apologize.
How much money do you make a month, sir?
900. Well, I would make 900.
900 every week?
Yeah.
You need to understand that DWI is big business in this country. What he's trying to do is he's trying to have me erase around $3,000 worth of surcharges that you would otherwise pay, not to mention court costs of another $400 to $500. So you could potentially be rolling out of here with around $3,500 in court costs. And if you don't pay it, you go to jail 1 day for every $100 you owe. So you could be doing a ton of jail time. You know, we're all allowed to make mistakes in lives, right? But the idea is that you don't continue to make mistakes where you endanger other people's lives. A second DWI, you're looking at surcharges of around $6,000. Do you understand? For $40, one button, an Uber will take you wherever you want to go. It don't matter how many beers, how many shots of tequila, take an Uber. Do you understand?
So,
All right, I'll waive it for you
I agree.
this time.
Yes, sir.
Well, that's it. You understand?
thank you.
All right, good luck.
Thank you.
Thanks, guys. What are the bond conditions that we have?
Judge, we have no contact whatsoever with Gracia Padron and Melissa Padron. We also have no drugs and no firearms, weapons, or ammunition.
So the assault is, who's the complaining witness in our assault case?
So on the assault here is Gracie Padron, and then the
You
felon.
know who that is in relation to this gentleman?
His partner's mother.
Yes, and then the partner is the complainant in the felony.
Okay. You're lucky to be out with as much baggage as you got, Mr. Warren. I mean, your history is just deadly conduct, unlawful carrying of a weapon, assault of a family member, violation of protective order, failure to ID, terroristic threat, violation of protective order, evading arrest, harassment, felony assault, failure to ID, criminal issue, violation of protective order, and now a felony assault and another assault. You're laughing like it's funny. It's it's sad because all of these cases that you have, no self-control. You get angry, you wig out, and that's not the way we work, man. I'm going to protect my community at all costs, Mr. Warren. And if I have to make your bond $2 million, I'm going to do it in a heartbeat to protect my community. Do you understand? You have one issue. I'm going to keep you. That's it. I'm not asking for much, man. Just don't have contact with these people. Self-control. Do you understand? It's not hard. What do you do with yourself these days? Where do you work at? Are you working full time? Great. Like full blown like you're working 40 hours a week?
Yes, sir.
Great. That's good. I mean, I'm making that a bond condition as well. I want them working 40 hours a week. When you have too much time on your hands, you get self-destructive, man. You just need to occupy your time, make your money, and just move on. Don't have contact, don't have any weapons, and then we're cool. All right?
Your Honor.
You got this.
Respectively, due to the nature how it's continuously picking up the same complainant, we would also request GPS monitor to reflect the felony who have GPS monitoring on that for the same reason.
He has a GPS monitor right now.
We'd want the bond conditions here to reflect that as well.
Is it through the felony court?
Yes, Judge.
Okay, so TAC Rs, you've got it on anyways. So know your every whereabouts. Don't go near these people. You got to charge it every single day, Mr. Warren. If you don't charge it, the battery's going to go dead. So does the bond. You understand? Okay, man. All right. Thanks.
Right this way.
Great.
May I approach? I'm doing well. How about yourself?
Does your guy have a BVR too? Yeah.
Sarah Castillo, Judge.
What's going on with that?
On December 31st, it looks like she reported for
Positive.
positive for alcohol.
Is she here now?
She's in the box, Judge. This is a single violation.
Come
Judge.
up, Miss Castillo.
It's the first time we've ever had any issue with her.
So-
We'll say I talked to her right after she learned that she tested positive. She sounded really sick. She sent me pictures of the NyQuil that she was taking that had alcohol. And Judge, I'm not gonna sit here and insult your intelligence and try and say that that's what it was. I'm
So, look.
not gonna do that, but.
If you ever test positive again, I'm now amending your bond conditions to put a leg monitor on you so I know that you're not consuming alcohol. If you ever test positive again, I don't care what it is. I don't care what anyone told you. You know, and you should know what you're putting in your body. I don't care what the excuse is. But if I find that you test positive, you have any more bond violations, I'm going to lock you up. That's it. Do you understand? Okay, so I'm amending your bond condition, put a scram on her ankle now, and I'll pay for it. Yeah. I want to make sure she's not consuming. If after a while she's not using, then we can talk, but I'm not going to take her word for it. We did that now. And where did it get us? So now I need more physical proof that she's not going to use. So now you're going to have a very cumbersome ankle monitor. You're going to have to explain to everybody what it is. Hopefully you get it. But court orders are court orders. And that's it. You're supposed to follow, and you don't. There are dire consequences. The next time you're going to stay with me. You understand? Okay. Here we go. I'll pay for it.
Okay.
And then here we are.
All right then.
All right, Colin. So we'll just do a normal setting, whatever you want, you know? Sure, yeah, absolutely. But
We're able to sit down and go through.
understand, it's no tolerance at this point. If I get another positive, if you fail to charge it like you're supposed to, if the battery goes dead, so does the bond. You understand? Okay. All right, Colin. Good luck.
Very good, Judge. Thank you.
All right. Please. Are you Miss Alani Jones? I'm sorry, Alani Keontae Gonzalez.
Yes, yes.
Miss Gonzalez, your lawyer's asked for me to set you a bond. You are a fugitive from justice. There's another state that wants you. I don't know why. I know that you're going to tell me it's little bunnies jumping in the woods, but I have to get to know you in a very short period of time. So please, let's get to meet Miss Gonzalez.
Your Honor, Ms. Gonzalez is one out of the state of Louisiana, specifically Baton Rouge Parish, for 2 offenses, the first felony larceny and the second monetary instrument abuse. I don't see that there's a bond there. She has no holds out of any other jurisdictions, Your Honor.
Any other criminal history? Okay. How old is she? How old are you, Miss?
23.
You're 23?
And Judge, yes, that is true. She has no criminal history. She is indicating to me that she lives in Houston. She works in Houston. She has no recollection of even going to this parish. I've explained to her that you will give her 14 days if you give her a bond to go down there and settle this matter. We have no information about the case that we can give to her. She needs to go to Louisiana and handle that. She understands that. She's never been in trouble, never been in jail. She's asking for you to set her bond so her family can bond her out and assist her in getting to Louisiana to address these issues.
I'm okay with giving her a bond. I mean, it's nonviolent. I don't have any, significant criminal history.
I'm not opposed.
So the next question is how much? Amy, guys, what do you say? What do you think?
Six just unopposed to a bond, but we'd be opposed to a loan. Maybe like 5,000.
Judge, I would ask for $1,500. She's 23 years old. She works at a bar on tips. Her family is willing to assist her. But I do believe that based on that information alone, that she's willing to do the right things, go and report back because she knows that you will issue a warrant for her arrest and bring her right back in the event that she does not obey these court's orders.
Ms. Gonzalez, you need to understand.
As a 3-year-old, you wanted me to.
You need to understand that these are serious charges and we take these really, really serious, If you want me to set you a bond, I will. I'll set your bond at $1,500, but you have to understand that you're going to have to probably pony up all of that money. It's not the 10% deal because you're a fugitive, meaning you are a flight risk in and of itself because it's out of another state. I will give you the opportunity to bond out, but I want you to understand we don't play games here. So if from the day that you're released, we give you 2 weeks to go turn yourself into Baton Rouge and take care of the business that you have there. You have to turn yourself in. There's no bond to post there. If you fail to do that, I'm going to revoke this bond. I'm going to set it at 0. I'm not going to give you another one. So if you fail to do it, I'm going to get you back because you can't run forever. And this time I'm going to hold you in custody until Baton Rouge comes and picks you up. Okay. You understand?
Yes, sir.
Okay. All right. So we'll set bond at $1,500 and then.
I will add she's waived, so she can name or withdraw her waiver tonight.
Okay. So she did waive.
Correct.
Okay. Have you spoken to any family members to make sure that they can make that bond?
No, Judge, I have not.
Okay. So the deal is this, is that, we give them 14 days to come pick you up, 14 days from the day that you waive. When did she waive?
Yesterday.
She waived today?
Yesterday.
Yes. So you have 1 day credit toward that 14 days. When you have to withdraw that waiver to be able to bond out. You lose that 1 day credit. And so that's why I would like, prior to you withdrawing that waiver, let Shibli reach out to your family to make sure they can make that bond because I don't want you to lose that 1 day credit, So we can put you back once you verify, or if you don't want to, that's okay too. If you know that they're going to bond you out regardless. I don't know. Sorry?
I can go call them right now.
Well, give the number to Shibli and Shibli can call back there for you and then you guys can talk back there. Okay? And then just let me know.
Yes.
Thanks. Around and around and around and around we have gone. One case, and now a second case, and now we have a bond violation.
Yes, Your Honor. I spoke with my client on January 18th, the family reunion. My client had ordered an Uber. The Uber canceled on him at about 8:40. And so he was going to order another Uber. His mother asked him not to do that. She said that she would take him home. And they ended up, there was a King Sayanyara. I'm not sure if I'm saying that right. But after that was over, then his mother took him home. That is why he arrived. One thing, his mother is here. Do you have any questions for that?
Is that mom there?
Yes.
She speak English? I'm not going to have you translate.
But Your Honor, he has had no other violations. He has 1 day of community service left on his PTI, and he is also currently working and should have the rest of the money for the restitution.
This is what we're going to do. I'm sending him for a drug and alcohol test right now. I want to know what, if anything, is in his system. And then we're going to go from there. So I'm sending you now for a drug test. And then let's just put it on for tomorrow. I want to know what the drug test, if anything, is going to say. Or can you be here tomorrow?
Yes, Your Honor.
Okay. I'm sending you for a drug test now, and then you're up here, right back here, so we can redo everything and see. It's unacceptable. You know what the rule is. You're under strict compliance with 2 cases that are open. This is not the first bond violation that we've had. I'm extremely upset with you, Mr. Gonzalez. I'm not taking any action now, but I want to see what the test says and we'll go forward tomorrow. Okay?
Okay. Do you want him to come back today? After
Tomorrow.
Okay.
I'm sending you for a drug and alcohol test right now. If you fail the test, if you fail to go, I'm going to revoke your bond. I want you back here tomorrow and I want to see what the results are and we'll go forward from there. Okay? Case. And you've now picked up a new case. What happened to the violation of protective order, please?
Yes, Your Honor. On March 18th, 2025, Harris County Texas officer met with Flight Menace for a BPO call for service. The officer met with Flight when he filed with the defense, sent her threatening text messages and called her 21 times. Claiming the city calls for 1 day after the 61-day protective order expired. The defendant has a no contact order in place out of Court 5.
You don't get it. You don't get it. I only have one thing to do. I'm sorry, I'm revoking your bond, putting you in jail. I ordered you not to do something and you're doing whatever you want to do. Doesn't work like that. There are serious consequences. Goes with you.
Who is this judge?
This is Montes.
Did you want another motion?
Yeah.
Okay.
Yeah. Oh, I'm putting a new MOA on him and I'm going to advise him that if he violates it again, we'll have a hearing to hold him at no bond. Okay? Because the second one, I can have a hearing. I will only touch the assault case and I'm going to put it at 5,001. He is made bond on the VPO.
He was given a PR.
They gave him a PR bond on the VPO. It's like, I don't know if I'm going to keep the PR bond on the VPO as well. Just.
Well, Judge, there were multiple orders in this case for bond conditions, and the one that ordered no contact was not labeled an order in the computer, so I didn't see it. There was another one that was no threatening or harassing, and a third one, and it was blank, and all it said was all conditions to be supervised by the department.
That means they're following the conditions in the state's motion filed on the same day.
Say it again.
Oh.
That
okay.
order will mean that they're supposed to be following the conditions in the state's motion that are filed on the same day as that transfer order.
Tell him ad nauseum, you know. I'll leave the VPO as is. Okay.
Yeah.
I'm putting a new protective order in today and I'll advise him that he's not to have contact with this person. And if he does again, I'll have a hearing to hold him at no bond. Okay. So yeah, the VPO, he's made bond 2,500 and at the assault, I'm putting it at 5,001. Okay.
Thank you, Judge.
Thanks. Good morning, Mr. Jordan. So you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 27, 2025, an officer was working a second job at Dick's Sporting Goods in Harris County, Texas, and was approached by the store manager, the witness. This advised the officer that the defendant walked into the store with another individual, and the witness advised the officer the other individual with the defendant walked out of the store without paying for any merchandise. The complaining witness stated he wanted the defendant to trespass because the defendant was seen on camera attempting to cover the individual while the individual was stealing merchandise. The officer stopped the defendant at the front entrance of the store, and the officer stated the defendant would be trespassing the store. The defendant became irate and more aggressive. The officer ordered the defendant to place his hands behind his back and place handcuffs on the defendant's right wrist. The defendant twisted his body and tensed his muscles. The defendant, with a great amount of force, threw his left arm forward and threw his left arm backwards towards the officer. The officer attempted to gain control of the defendant's left arm. The defendant began pulling away, and the officer grabbed the defendant's body with both arms and guide the defendant toward a rack where the officer was able excuse me, Your Honor, tongue twister, where they were able to detain the defendant. The defendant was identified by his Texas driver's license.
What's he under arrest for?
I believe he was under arrest for trespass originally, Your Honor.
No.
We have,
You gotta,
yes, Your Honor.
are you losing? Are you losing?
Your Honor, the only thing I have is that the suspect began acting irate and clearly becoming more aggressive. And then the officer went to detain the suspect by grabbing his right wrist.
No. All right. When you get into a pissing match with the people who have the power of arrest, who's going to win every single time? You know what I mean? Every single time. Sometimes it's better to tuck your tail. At times, because you may end up winning in the long run. I'm going to find no probable cause in the case. Just be careful, man. I probably wouldn't go back to the sticks because it's not going to go well. You know what I mean? All right, hang tight.
I am here on Destiny Drake Osby. Yesterday, you ordered that she appear today. I was appointed last Friday. She caught a new ag assault family member in another court.
No.
She is in court 8's holdover right now.
Do you mind bringing up, please?
Last name is Drake-Osby. The case before you, like I said, it was recently appointed a week ago today. It looks like the arrest was the following day for whatever this new thing is.
This is for the.
Well, no, the new law violation that she caught in felony court.
Hold on before, because I want her to hear it.
Gotcha.
I'm in shock. You're on bond for a DWI with us, and you've now picked up an aggravated assault of a family. Do you mind, this is Ms. Drake Osby. What happened in the ag assault, please?
Yes, Your Honor. On April 1st, 2020, as first specified, the plaintiff and the defendant are exes from a prior dating relationship. On April 1st, 2025, an officer was dispatched to an address in Harris County, Texas, responsible for disturbance call. The plaintiff stated there was a verbal altercation when the defendant took the plaintiff's cell phone. The defendant then entered the bedroom and began striking the phone and objects to break it. The plaintiff was able to retrieve his cell phone, at which time the defendant began to strike the plaintiff in the head and torso with a closed fist, causing him to fall on the ground. The plaintiff was able to walk away, and the defendant grabbed a metal object and struck the plaintiff in the head and arm, causing 2 lacerations on his left eye and a laceration on his right eye, and multiple scratches on both arms. The defendant then jumped the fence and fled the scene. The object was a solid metal bracket, 12 to 16 inches in width, made of heavy gauge steel designed to hold 2 cylindrical metal tubes and has multiple sharp forms. The item is manufactured for law enforcement officer use as a mounting or deployment device for tire deflation.
And all this over a phone? Ms. Drake Osby, I now have to revoke your bond in our case as well. I'm sorry. So I'm going to set it at 5,001. You've still not made bond on the felony case. So if you do, I mean, we can talk, but John, I think he's set for when? She's set for
514, Your Honor. Yes, sir.
Okay. Do you want to do, I guess, the day after then?
You look at one other thing, Judge. Well, I think the felony is actually set for Monday. Our case before this one was caught up was when she was reset for 514.
It's up to, I'm good with whatever you want to.
I'm actually looking, I don't have any new discovery to look over because this case is so new. There weren't even any body cams for me, so I'm pretty much waiting on everything. I'll leave it where it is and I'll monitor things and see what's going on with the felony case, Judge.
All right. Thanks.
Thank you, Judge.